Ever wondered how you can ensure your final wishes are legally protected? Are you preparing for the Philippine bar examination and need a clear, concise understanding of wills under the new civil code? Join us as we explore the essential legal concepts surrounding notarial and holographic wills, including the critical stipulations on joint wills as provided by Republic Act 386, also known as the New Civil Code of the Philippines, Articles 804 to 819. This topic is not only vital for ensuring legal accuracy in document preparation, but also features prominently in the Philippine bar examination. Stay tuned as we unpack these concepts, providing a robust foundation for law students, bar examinees, and practicing lawyers alike. Don't forget to subscribe to our channel for more indispensable insights into Philippine law.
Part 1: Overview of Wills in Philippine Law. In the Philippines, the will is a powerful legal instrument that allows an individual, referred to as the testator, to dictate how their assets are managed and distributed posthumously. The new Civil Code provides a framework to ensure these documents meet legal standards for validity and enforceability. Part 2: Notarial Wills. Article 805 mandates specific requirements for a notarial will, ensuring its validity through formal witnessing and notarization. This traditional form of will requires documented form. The will must be written and signed by the testator and at least 3 credible witnesses in the presence of each other and in notary public. Witnesses. The role of witnesses is critical, as they attest to the authenticity of the will and the capacity of the testator. Notarization. A notary public must acknowledge the will, confirming the identities of all signing parties and their voluntary participation in the process. Part 3: Holographic Wills. Providing a more personal option, Article 810 outlines the requirements for a holographic will, which offers simplicity and privacy. Handwritten. It must be completely handwritten, dated, and signed by the testator. No witnesses needed. This type of will does not require witnessing or notarization, making it easier and quicker to execute, especially in urgent situations. Part 4: Prohibition of Joint Wills. Article 818 clarifies that joint wills, or wills created by 2 or more people in one document, are illegal in the Philippines. This law aims to prevent complications and potential disputes that could arise from combined testamentary intentions.
Part 5: Importance of understanding wills. For legal professionals and students, understanding the intricacies of will preparation is crucial for several reasons. Advisory role. Lawyers must accurately advise clients on how to structure wills to ensure their enforceability. Examination preparation. Knowledge of these laws is essential for success in the bar exams and for future legal practice. This exploration into the legal requirements for notarial and holographic wills, along with the prohibition on joint wills, is designed to equip you with the knowledge to navigate these laws confidently. Proper understanding and application of these principles will ensure that the wishes of the deceased are respected and legally protected. Subscribe now to stay ahead with the latest updates and expert knowledge in Philippine law, helping you succeed in exams and professional practice. Frequently asked questions. 1. What is necessary for a holographic will to be valid in the Philippines? Answer. As stipulated in Article 810, a holographic will must be entirely handwritten, dated, and signed by the testator to be valid. It does not require any witnesses or notarization. 2. Are joint wills allowed for married couples in the Philippines? Answer. No, according to Article 818, joint wills are prohibited regardless of the testator's nationalities. Each spouse must create a separate will. 3. What are the formal requirements for a notarial will? Answer. Article 805 requires that a notarial will be signed by the testator and at least 3 credible witnesses, each of whom must sign the will in the presence of each other and a notary public, ensuring its legality and validity. Bar exam questions. Question: Miguel, who died single and childless, was survived by his 2 legitimate brothers Romy and Raleigh, and his nephews Arno and Pabs, the legitimate sons of his predeceased legitimate brother Edgar. Before his death, Miguel executed a 1-page notarial will, inclusive of an attestation clause and a notarial acknowledgement, with only one testamentary disposition bequeathing his entire estate to Romy and Raleigh. The will was not paginated and was attested by 4 witnesses, uno, dos, tres, and cuatro. It was the eve of Cuatro's 17th birthday when the will was executed. The will was written in the Ilocano dialect, which Miguel knew and understood, but the witnesses did not. Miguel and the witnesses signed at the end of the testamentary disposition. The attestation was also written in the Ilocano dialect which, when translated to the English language, reads as follows: This will of Miguel was written in 1 page. We, the attesting witnesses, signed at the end of the will and at the bottom of this attestation in the presence of Miguel and of each of us. Each of the 4 witnesses signed below the attestation clause. Because none of the witnesses knew and understood the Ilocano dialect, the attestation was interpreted to them by Miguel's lawyer who was present to notarize the will. 2022 Bar, A. A. Does the fact that the will was written in a dialect known only to Miguel invalidate the will? What about the absence of the marginal signatures of the testator and the witnesses? Answer: No. The law requires that the will must be written in a language or dialect known to the testator, art. 804, NCC, but it does not require that the language of the will be known to the attesting witnesses. On the other hand, the lack of marginal signatures will not invalidate the will because the will was contained in only 1 page, and since the testator and the witnesses signed at the bottom of the instrument, it would be superfluous to still require that they marginally sign the 1-page will. Central Bar QA, by Pagwiragan, 2023. B. May the will nonetheless be admitted to probate? Explain briefly. Answer: No, the will may not be admitted to probate because of the defective attestation clause. The attestation clause must state the number of pages used in the will and the fact that the testator signed the will in the presence of the attesting witnesses, and that the witnesses signed the will not only in the presence of one another but also in the presence of the testator. The attestation clause in Miguel's will failed to state that the attesting witnesses signed the will in the presence of the testator. Thus, the attestation clause is fatally defective, which renders the will void. Canida v. Court of Appeals, GR number 103554, May 28, 1993, Central Bar QA by Pagwiragan, 2023.
Problem number 2. Arthur executed a will which contained only I. A provision disinheriting his daughter Bernica for running off with a married man, and 2. A provision disposing of his share in the family house and lot in favor of his other children Connie and Dora. He did not make any provisions in favor of his wife Erica, because as the will stated, she would anyway get 1/2 of the house and lot as her conjugal share. The will was very brief and straightforward, and both the above provisions were contained in page 1, which Arthur and his instrumental witness signed at the bottom. Page 2 contained the attestation clause and the signatures, at the bottom thereof, of the 3 instrumental witnesses, which included Lambert, the driver of Arthur, Yoli, the family cook, and attorney Zorba, the lawyer who prepared the will. There was a third page, but this only contained the notarial acknowledgement. The attestation clause stated the will was signed on the same occasion by Arthur and his instrumental witnesses who all signed in the presence of each other, and the notary public who notarized the will. There are no marginal signatures or pagination appearing on any of the 3 pages. Upon his death, it was discovered that apart from the house and lot, he has a P1 million account deposited with ABC Back. What other defects of the will, if any, can cause denial of probate? 2008 Bar. A. The other defects of the will that can cause its denial are as follows. A. Attorney. Zorba, the one who prepared the will, was one of the 3 witnesses, violating the 3 witnesses rule. B. No marginal signature at the last page. C. The attestation did not state the number of pages upon which the will is written. And D. No pagination appearing correctively in letters on the upper part of the 3 pages. Oswella v. Court of Appeals, GR number 122880, April 12, 2006.